Hi friends from around the world. This is about the epic battle between Samsung and Apple. When you are new to intellectual property, you may not recall it. If you are more than 5-10 years in it, then you may have heard of it. Now, they both, between Apple and Samsung, at a certain moment, they have more than 50% of the market share of global mobile and tablets. So two giants, so to say, battling over the supremacy in the tech world, in the mobile world, tablet world. We are all in. And it started in 2011 or so, where the origin was Samsung, which were about patents which Samsung claimed they were yours and they were used by Apple. Now, Apple was not lazy with regard to its own pretensions, and then it started left and right about patents and about design rights mainly. Not about trademarks, right? Apple and Samsung are quite different. But design rights and patents, that were the main battleground they were fighting. And they were not fighting in one territory only. So in 2011, there were some 18 cases in 8 countries. August and in October that moved to 10 countries, and in July 2012 we had already 50 lawsuits all around the globe, whether it was the US, whether it was Europe with UK, France, Germany, Netherlands, and other countries as well. So even there were some design invalidity claims pending at EUIPO against the designs from Apple. Well, what we have about here is a UK case. The UK case. Well, let me talk about one issue which was in the Germany and the Netherlands. That is an issue which took place in 2012. So it was infringement cases against Apple in preliminary injunctions against Samsung. Apple against Samsung, and it was on design rights, right? So they wanted the infringement, so stop the infringement claim of Samsung on designs. Now, Germany has come across a lot with regard to infringement and enforcement. And, well, Germany was in favor of these infringement and on the RCD right. And at first it admitted the Apple suit, the Apple pretensions, the Apple claim, and on the RCD, on the registered community design, right? And which, when afterwards, it was limited on unfair competition and only limited to Germany, whereas previously it was for more countries adopted. Now, the same pretensions were also filed in the Netherlands. But in the Netherlands, the minimalistic designs of Apple were such as a way that the judges in the Netherlands, they did not come to the same conclusion. On the contrary conclusion, they said, well, in the Netherlands, there is no preliminary injunction granted in favor of Apple. So you have this situation where you have the same subject matter, and you have one judge declaring in Germany one thing and another judge in the Netherlands declaring the contrary. Although the Dutch in the Netherlands, that was afterwards, after then the Germany won, so they could have known the German, and they should have known the German ruling or order on the preliminary injunctions, but they decided contrary. So that happens in these enforcement cases. If it's not coming to the European Union and pending on one issue which is being decided commonly for the whole European Union. Well, in this case, it did not come to the European Court of Justice. And all of the cases, not even one came to the European Court of Justice. At a certain moment, there was a settlement, and then the cases did not went into further instances. So they did not come up to very high in the ladder of the litigation instances. So I would come to the UK case, and why did I choose the UK case rather than going into the loop? Well, if I'm going into the loop in order to 50 cases to declare to you or to explain to you, I would go mad, but you would go mad as well, or you would turn me down at a certain moment. So that is not my intention. But that case, I chose that case because, well, first, this is a case from the common law perspective. I'm not a common law, so to say, expert. My background is Germany, so continental law. But there are some things in common law where the judge is named by its name. Well, we in continental law, we wouldn't name any judge. We wouldn't know any judge by name. The judges, Justitia is blind, so to say. So nobody on the Justitia, on the judge's level, is at the personality is well known or so. In common law, that is the case. And here we have the Judge Burs. And the Judge Burs rendered a judgment. And the judgment also are redacted in a different way than in the continental law. Continental law is very dry and boring, whereas the judges, so if this is my judgment and I have ruled this, then they do it a bit differently. And Judge Burs did it a bit differently. So I would encourage you afterwards, once you have heard the video here, to go into that judgment. It is easy to read, and it will give you some illustrations, namely on the comparison of the prior art with regard to the Apple ones. The Apple ones and the Samsung ones. So what was about the designs, right? The designs, so it was initiated by Samsung against Apple on non-infringement, so that the Samsung designs were not infringing the Apple design. That was the pretension. And then we have a counterclaim from Apple, naturally, by saying, well, it is an infringement case, so they are infringing the Apple designs. And there is one issue that I think there are two issues here on proceedings which merit a mention. One is the staying of the proceedings, which is foreseen in Article 91(1) of the Community Design Regulation here on the screen. And this is at the discretion of the judge. So the judge can say, well, if there's an invalidity claim, if, for example, at EUIPO, which was the case here, invalidity claim against the designs of Samsung, if there's an invalidity claim pending, then it should be stayed the proceedings in order not to get to do different results here. Whereas it is at the discretion of the judge to say, well, I have reasons not to stay the proceedings, but I still want to go ahead because, well, because I think there is no invalidity here. I think this one will take, so about the invalidity, this will take years to decide, and I want to decide now. There are many reasons that can be, well, at the discretion of the judge. And the judge, in that case, it said, well, I will go ahead. This is the first thing. The second thing is on Article 84 of the design regulation, which says that the invalidity of the design in non-infringement cases, which was here presented by Samsung, in non-infringement cases, the invalidity of the design, in that case the Apple design, is not being questioned. So even if Samsung said, well, this design is invalid, that is not something the court can take into account due to Article 84 of the design regulation. But that does not mean that the prior corpus, so to say, is not being taken into account. It is in a certain moment in order to make the overall assessment of the informed user. Now, I do not want to go into the details of the comparison with regard to the designs of the one and the other. That is an issue you should look up there. There were 7 different features which advanced by Apple, which confirmed, so to say, according to them, that there was an infringement of their design, and mainly on the front, from the front. And the Samsung naturally said, well, it was all familiar, it was all over by then, that type of design in other cases. So that is not really infringement, and because the informed user, they would not get attention on the front page. They are all the same on the front view, so to say. They are all the same. So they would rather go to the side view or to the back view in order to look at differentiation with regard to the designer. And the judge, well, it came to that view, to the, so to say, Samsung view, through the informed consumer. The informed consumer is not the average consumer, you know that, not the average consumer in trademark issues who just, is somebody who is not knowledgeable, not particularly knowledgeable, unless it is the professional consumer. The informed consumer knows about a certain level. He is a kind of, not a real expert, but it is a bit more like an expert than the mere average consumer. So if there are some, if it is that the front view is not so different from other models on the market by the time, then it would not be that the informed user would take the front view in order to distinguish, well, that is a new design, that is a different design. He took the view that the side view and the back view are more important for the informed user. They are more important for the informed user here because, and that was interesting, because there were some, there are some clubs from around the world of Apple pundits who want, who closely follows all the products which are published by Apple, but they also advance future products, potentially products, because they think that could be in this way, and they advance, so to say, what would be the release of the products afterwards. Or there may even leaks, I don't know, leaks from the company, from Apple, so they get to know what is the intention of Apple to is next generation of tablets or mobile phones or whatever. So these are published. These are published. The clubs they publish their findings or their speculations, whatever it is. Now this kind of publication is that prior art. That was a question which has been put forward by Apple by saying no, that is not prior art, that is not being taken into account. On one hand, while it is potential, it is not really a product on one hand, and on the other, this is only to specialists, open to specialists. The clubs, they are pundits, they are nerds, they are, it's not the informed user in general. But the judge Bers, so he went a bit into that way of Samsung, and at the end, well, he he ruled, so to say, in favor of Samsung. Now, I don't know whether this judgment had a big impact on what was the final settlement between the two giants on the mobile, on the tablet space, but it is an interesting one. And I think, well, there is a reasoning which I found quite attractive with regard to the informed user and with regard to the not to take into account the front view, but the side view and the back view more. That seems to be quite novel for me. Well, it is an argumentation which you also can perhaps use in some case law you may have from in your home jurisdiction or wherever it is. That was part of the epic battle between Samsung and Apple.